Okay. Aloha mai kako. Good morning. This is the December 23rd Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program in order to comply with state and county official operational directives during the ongoing COVID-19 pandemic. Members of the public are able to view the meeting via the Zoom webinar platform. For all meeting participants, I'd like to stress for you the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, it is helpful if you state your name for the record to identify yourself. Also, please be aware that this meeting is being digitally recorded. Your continued participation is your implied consent to be part of the public record for this event. If you do not wish to be part of the public record, you should exit the meeting now. As we now know, the Zoom conferencing technology allows all the parties and each participating commissioner individual remote access to the meeting via our own personal digital devices. Because of that, and often due to matters entirely outside of our control, occasional disruptions to connectivity may occur. If this happens, please let us know and please be patient as we try to restore audiovisual signals to be able to conduct business during the pandemic. For members of the public who wish to testify during the public witness portion of this meeting, when it's that time, I'll ask you to use the raise your hand function in the Zoom software. You can do this by pressing the raise hand button, or if you happen to be calling in from a telephone, by pressing the key sequence *9. You also need to press the key sequence *6 to unmute. But if you're via the Zoom software, there's different controls. We will take breaks from time to time, approximately 10 minutes every hour. My name is Jonathan Lee Scheuer, and I have the distinct pleasure and honor to be serving as the Land Use Commission Chair. And I reside on the island of Oahu. We currently have 8 seated commissioners of a possible 9, along with me, Commissioners Chang Okuda, our Executive Officer, Daniel Ordinker, our Chief Planner, Scott Derrickson, our Staff Planner, Riley Hakoda, our Chief Clerk, Natasha Quinones, and our Deputy Attorney General, Linda Chow, all are on the island of Oahu. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Lee Ohigashi is on Maui, and Commissioner Dan Giovanni is on the island of Kauai. Court reporting transcriptions are being done from the Zoom recording. So that is another reason why it's important to speak slowly, distinctly, and directly into your microphone. I will note that Commissioners Arnold Wong and Edmund Axon are excused from today's meeting. Our agenda item for today is an action for docket number DR 2176, KEKAHA Agricultural Association, Kauai, to consider a petition for declaratory order to designate approximately 12,123 acres at KEKAHA, Kauai, tax map key 4-1-2-002-001, a portion thereof as important agricultural lands. Will the parties please identify themselves for the record, beginning with the petitioner, followed by the county and the Office of Planning and Sustainable Development.
Good morning, Chair, Commissioners, and staff. My name is Doug Kodaga, outside counsel for the KEKAHA Agriculture Association petitioner in this matter. With me here today is Tom Schnell of PVR Hawaii, our consultant. And also available to answer questions as needed is Mr. Joshua Uehara, who is the manager of Hartung Brothers Hawaii, one of the members of the co-op, and also the president of the board of directors.
Thank you. Kauai County.
Good morning, Chair, Commissioners, and staff. This is Laura Barzilai, Deputy County Attorney representing the Planning Department of the County of Kauai. With me is Marie Williams, manager of our long range division of our Department of Planning. I don't think she's been promoted as a panelist, but she is available. Thank you very much.
I will promote her right now.
Thank you, Chair.
OPSD.
Allison Kato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here with me are Lorraine Maki and Mary Alice Evans from the Office of Planning and Sustainable Development. Thank you.
thank you. Now let me update the record. On December 2nd, the Commission received a petition for declaratory order to designate important agricultural lands, a verification, Exhibits A through D, a certificate of service, and a filing fee of $1,000. On December 6, 2021, the Commission received the Agribusiness Development Corporation's testimony in reference to the KAA IAL petition. On December 13th, the Land Use Commission mailed a meeting agenda for the December 23rd, 2021 meetings to the parties and to our statewide and Kauai County mailing lists. On December 15th, OPSD filed its response to the petition. On December 16th, the County of Kauai filed its response to the petition. Also on December 16th, the Commission received the Department of Agriculture's comments. And on December 17th, the Commission received the Agribusiness Development Corporation's supplemental testimony with additional RAPs for reference. Also on the 17th, OPSD filed a supplemental comments and certificate of service. In addition, public testimony was received from Grant Kunishima on behalf of Sunrise Capital and Kauai Shrimp. And last night, and this will be posted to the website at approximately, 12 a.m. As the chair, I was sent testimony from the Department of Hawaiian Homelands by its chairman, William I. Law, seeking a deferral of this matter, or in the absence of a deferral, a contested case. That testimony will be posted to the website. I also note Chairman Ayla is an attendee in this room, so we'll perhaps be giving oral testimony as well. I'm going to pause now and ask for any disclosures at this time, and I'm going to go first. I was going to disclose this anyway. I work as a consultant for the Department of Hawaiian Homelands on implementation of their water policy plan. I have actually been involved in certain matters in an advisory capacity in this area as a number of parties, which includes the Agribusiness Development Corporation and DHHL, seek to implement what is called the Waimea River Settlement, which was agreed to by all the parties a number of years ago. I believe I can be fair and impartial on this matter. So I would like to ask the parties if there are any objections to my continued participation. That said, I will also note for you that if there is an objection to my continued participation, I would hand over the duties, at least temporarily, to the Vice Chair, Dan Giovanni, to consider any objections and ruling upon them. If it is ruled that I cannot participate in this matter, that would actually end today's hearing, because for an important agricultural lands matter, you need 6 commissioners to pass the matter. So we would immediately defer action today. Mr. Kodaga, any objections?
Chair, thank you for the disclosure and for the information. Before I answer that, may I just quickly request clarification as to whether there would be an opportunity to caucus with my client on that disclosure. If not, that's understandable. I believe that there is no objection. However, I'm unable to confirm that with my client based on the information you just provided.
Do you want a 2-minute recess?
I would like, yes, if I may.
Okay, we'll give you 5. It's 9:09. We will reconvene at 9:04. 2 minutes is fine?
Yes.
It's 9:09. We'll reconvene at 9:11.
Thank you.
Okay, it's 9:11. We're back on the record. Mr. Kodaga.
Thank you, Chair, for the opportunity to caucus with my client. We appreciate that and apologize for any inconvenience. We have no objection.
Okay,
moving
thank
forward.
you very much. Kauai County.
Chair, my client and I have no objection.
Okay, thank you. OPSD.
No objection. Thank you.
Okay, thank you. Commissioners, are there any other disclosures that people wish to make? Commissioner Okuda.
Thank you, Mr. Chair. To the extent necessary, I'd like to disclose the fact that I worked with Patricia Teruya, one of the commissioners on the Hawaiian Homes Commission, with respect to a vaccination clinic in Nanakuli. Commissioner David Ka'apu, I know for decades from the practice of law, although I have not spoken to him since the time that he has been appointed to the commission. I have spoken with Randy Awo, another commissioner, with respect to some issues regarding long-range planning, but since the time he was appointed to the commission, I don't really recall speaking to him about any pending matters. So I make those disclosures.
Thank you, Commissioner Okuda. Any objections to Commissioner Okuda's continued participation? Mr. Kodaga,
No objections.
Ms. Barzilai,
No objection, Chair.
Ms. Kato.
No objections.
Thank you. Commissioners, anything further? Okay. Now let me go over, Commissioner Giovanni.
Get my video on here. Just a point of clarification, Chair. Mr. Uehara was introduced as a member of the co-op. Could you clarify, please, the organization in more detail, who he represents?
And Mr. Kodaga.
Yes, thank you, Commissioner Giovanni. The petitioner is an agricultural cooperative formed pursuant to Chapter 421 Hawaii Revised Statutes. It is led by or governed by a board of directors. The board of directors, of course, has a president, and Mr. Uehara is president of the KEKAHA Agriculture Association Board of Directors, and he is participating today in that capacity. And that is because the petitioner is the KAA. The KAA, of course, is a co-op comprised of members. One of the members is Hartung Brothers, and Mr. Uehara is the manager of Hartung Brothers.
Very good. Yeah, thank you for that clarification.
Absolutely.
Thank you, Commissioner Giovanni. Thank you, Mr. Kodaga. Anything further, commissioners? Let me go over now our procedures for this docket. First, I will give the opportunity for the petitioner to comment on their agreement or disagreement with the Commission's policy governing reimbursement of hearing expenses. Next, I will, before proceeding further on the matter, we will acknowledge any written testimony. I will then ask for a commission's discussion regarding and ask the parties to address some concerns over the ability of the petitioner to file this petition, specifically whether or not there is a requirement that they need the assent of the Board of Land and Natural Resources prior to us considering this petition. Should those issues be resolved in full to the Commission's satisfaction, we'll then proceed to hearing on the full petition. Commissioner Chang.
Thank you, Mr. Chair. I would like, as a procedural matter, in light of DHHL's notice, and I have not read the correspondence or what they filed, if they are requesting a contested case hearing, I am concerned about further procedure, us conducting a hearing on this matter without addressing the contested case, if that is a request. So I'd like at some point in time for us to address that.
So thank you, Commissioner Chang. And sorry, Mr. Ordenker, obviously things have been moving around a little bit. If we allowed for public testimony prior to taking up any of the further deliberation about the timing of this case, would that be able to address those concerns? Ms. Chow.
Yeah, I think I'm going to defer to counsel on that.
Ms. Chow.
Yeah, maybe I can better address that. So I'm looking at the request right now, and it's made as a conditional request. So it's saying if the matter is not deferred, then they want a contested case. So I think the issue of whether or not the matter is going to be deferred can be taken up first. And if the decision that is made that it will not be deferred, then I think we have to deal with the question of the contested case and whether or not a hearing can go forward without dealing with the contested case first.
And if I may, Ms. Chow, I believe there's also a question that would arise on whether or not it is possible to be granted a contested case on the declaratory ruling. Is that correct?
Correct. But again, if decision is made to defer, then we have more time to look at that issue later.
Okay. Commissioner Chang.
Nope, I am fine with that. I will defer to our council's advice on that.
Okay.
So,
So my preference is seeing a number of people in the waiting room. If people are here to testify, my inclination, and I guess this is a question for council, for our council. If people are here to testify, are we harming the process in any way by allowing people to testify prior to taking up the issue of deferral?
I think if you ask people to limit their testimony to the issue of deferral first, then no. They, obviously, if that's the issue that's going to be taken up, you can obviously get testimony on that. As far as testimony on the petition itself, I think it'd be better if we could hold off on accepting that testimony until we get to the issue of whether or not you can even hear or proceed with that IAL petition in substance,
Okay.
before you deal with the contested case request.
Okay.
Mr. Chair,
Mr. Ordenker.
assuming for the moment that we are addressing an IAO petition with regard to public lands, section 205-44.5, just for everyone's understanding, says that section B, the designation of important agricultural lands pursuant to this section shall not be subject to the district boundary land procedures of 205-3.1 or 205-4 or declaratory order procedures of section 205-45. So as basically that section is consistent with the rest of the IAL statute, totally unclear, but it appears that the rules regarding declaratory rulings may not be applicable in this case. So I don't know where that lands us.
Okay, so we're still in the discussion of procedures for today. So my preference is, in the interest of, if people show up from the public and they want to testify, unless it's prejudicial to the proceedings, I like to provide people the opportunity to testify. And I will give actually all the parties the chance to comment on this, just as I would normally when I lay out their procedures for today. So my proposed procedures are this. I'm going to acknowledge written testimony. I'm going to allow for oral testimony from any members of the public, but I would like it to be limited to the issue of potentially deferring this item because of an ongoing question, whether or not KAA is able to properly bring this matter before us prior to having an action in assenting to this from the Board of Land Natural Resources. After the closure of that portion of public testimony, the commissioners the chair will allow for each of the parties to comment on this, the commissioners to ask questions. We will then make a determination on whether or not to proceed or not. I will then, if we choose to proceed and not defer, I will then open up testimony again to have people testify on the substance of the proposed IAL. If we propose to defer, people will get an opportunity if and when the petition comes before us again. I'm going to check with the parties. Is the procedure clear, and do you have any concerns with the procedure? Starting with Mr. Kotico.
No objections, Chair. That's clear.
Thank you.
It's
Clerk
clear,
Hoffman?
Chair.
Okay.
Same.
Okay. So that's our procedures for today. The only thing I left out in that last thing is that I need you to go over whether or not you assent to the reimbursement of hearing expenses as explained in our administrative rules. Mr. Kotiga?
No objection.
Okay, thank you. So what we're next going to do is we're going to offer the opportunity for public testimony on this matter, but I'm asking all members of the public who wish to testify to limit their testimony solely to the matter of whether or not this petition's consideration should be deferred today or not. If you are here to testify, please either use the raise your hand function in the Zoom software, or if you are calling in by phone and we have one phone in caller, use the star sequence the key sequence *9 to raise your hand. I see one hand raised at this point, Beth Tokioka. I will admit people to be panelists. I will swear them in, ask them to identify themselves by name and address for the record, and then give them the opportunity to testify. So Beth Tokioka, followed by William Ila. Okay, you should now be able to enable your audio and video, Beth. There you are. Okay.
Good morning.
Good morning. So I'm going to swear you in and then ask you to identify yourself, and then you proceed with your testimony. Do you swear or affirm the testimony you're about to give is the truth?
Yes, I do.
Okay, thank you. So if you'd state your name and address and affiliation for the record and then give your testimony, please.
Sure. Aloha. My name is Beth Tokioka. I am with Kauai Island Utility Cooperative. Our address is 4463 Pahe'e Street, Suite 1 in Lihue. Appreciate the opportunity to address the matter of deferral. We at KIUC do support deferral of the matter. We have some concerns about the petition as it is presented. Unfortunately, we only learned about the petition yesterday, so deferral would allow us time to better address the concerns and for your consideration at a later date. So thank you very much.
Okay. Let me see if there's any questions from the parties or the commissioners for you. Mr. Kodaga.
Thank you, Chair. We have no questions.
Kauai County.
No questions, Chair.
OPSD.
No questions, thank you.
Commissioners. Commissioner Okuda.
Thank you very much, Mr. Chair. May I ask, how did you find out about this petition? And if you had any suggestions on how maybe communication might be better in the future, whether or not such procedures are really required by the rules or the statute?
We just, someone alerted someone on our staff, our senior staff, that this item was up on the agenda. We have not we are concerned about the agenda item as it relates to the West Kauai Energy Project, which we're currently developing. And there are a number of agencies that we monitor regularly for agendas when we anticipate items might be coming up related to the project. The LUC is not something that has been recently on our radar screen, so we weren't really monitoring. But I didn't take the call, but someone was alerted that the agenda item was there and could potentially have an impact on the project. So.
Okay, thank you.
Monitoring the agendas more fully in the future.
No apologies are necessary, and thank you very much for participating in the process. I believe more participation is usually better than less participation. So thank you very much. No further questions, Mr. Chair. Thank you.
Thank you, Commissioner Okuda. Commissioner Ohigashi.
I'm sure that it might be too early for you to determine this, but are you also going to consider joining in any intervention in this matter if it is allowed?
We have not discussed that, so I'm unable to answer that question at this time. But a deferral, I think, would address our concern to be able to more fully prepare and share with you our concerns about the submittal as presented.
You mentioned that there was some project that was adjacent or close to this area. Do you have any kind of interest adjoining the project area or in the project area or in the area to be designated? Is there some kind of interest that your company, I guess,
yes, there is. I'm not sure if it's proper to get into the content, Chair.
I think if you would give just enough context.
Okay, sure.
For the broad basis of why you're even concerned, why you're here and concerned to seek a deferral.
Sure. Very briefly, the West Kauai Energy Project is a renewable project that we are developing on the west side of Kauai. It's a pumped storage hydro project and encompasses infrastructure on state lands, including ADC lands, including the Manau Reservoir, and would require us to construct some facilities at the reservoir, also rehabilitate the reservoir. And we just want to make sure that these facilities that are, and it's a very small amount of acreage, but it is primarily for energy production. Although the project will support, with the rehabilitation of the reservoir, will support the agricultural purpose of KAA. But there are some facilities that are needed for energy production that don't have a direct nexus to agriculture that would need to be constructed on these lands. Again, it's a very small acreage, but we would ask that acreage be carved out or acknowledged in whatever decision is made that project, those could be constructed on these lands and that the project could go forward.
If there is a deferral, I look forward to reviewing what submittals have. Thank you.
Thank you.
Thank you, Commissioner Higashi. Commissioners, further questions for the witness? Seeing none, thank you very much, Ms. Tokioka.
Thank you.
I'm going to move you back to being an attendee, and I'm going to promote William Ilaw. And anybody else who wishes to testify should use your raise your hand function to indicate your desire to testify. If you're calling in by phone, use the key sequence *9. Mr. Ilaw, if you can enable your audio and video. There we go.
Yes, thank you, Chair Scheuer. And I apologize. And I'll answer some of the questions up front.
Chair Ilaw,
yes.
I need to swear you in.
Oh, sorry.
Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay, and just if you could just state your name for the record and then proceed.
Sure. William J. Ilaw, Jr., Chairman of the Hawaiian Homes Commission, Director of the Department of Hawaiian Homelands. Our address is 915420 Kapolei Parkway, Kapolei, Hawaii 96707.
Thank you very much. Please proceed.
Okay, so I will just apologize to you and apologize to both the petitioner and the Land Use Commission for the last minute notice. I learned of this agenda item on the LUC docket late yesterday evening from a consultant with KIUC, and support the request and request ourselves a deferral. It has no reflection on, I think, KAA's request for the important agriculture lands. However, until we understand how this is going to impact KIUC's energy project, and closely related to that, our settlement, the Department of Hawaiian Homeland settlement project going forward, where we would assign subsistence agricultural lots in West Kauai based upon the implementation of the energy project. We just need more time to understand how this action could impact that process moving forward.
Are there any questions for the witness? Mr. Kodaga.
Thank you, Chair. We have no questions for this witness at this time.
Okay. Hawaii County, Ms. Barzilai.
No questions, Chair. Thank you.
Ms. Kato.
No questions, thank you.
Commissioners. Questions for Mr. Ilaw, Chair Ilaw. Seeing none, I suppose. Thank you very much for your testimony. And
I'll just say thank you, Chair, and Merry Christmas and Happy Holidays to you all. Mahalo.
Thank you. I'm going to move you back to being an attendee.
Thank you.
Okay, last call for any public testimony regarding just the narrow issue of potential deferral of this item. If anybody who is attending this meeting wishes to testify, either use the raise your hand function or *9. Seeing none, we're now going to proceed with a consideration on a sort of determinative matter on how much further we can go today. So we need to determine whether or not the petitioner has the proper authority to file this petition. This matter is preliminary and dispositive of the petition. As of today, the LUC staff does not believe it has received a complete explanation and supporting evidence of KAA's authorization to file the petition, who had to grant that authority, and whether or not the proper process was adhered to. As of today, we have received documents indicating that counsel for the petitioner has the authority to file a petition with the commission on behalf of KAA. And we've received minutes of a meeting from the Agribusiness Development Corporation from January 3rd of 2018, along with submissions from that meeting and a map purporting to be DLNR Executive Order 4007. We've also received testimony from the Office of Planning and Sustainable Development that the lands subject to the petition are, quote, not public lands, end quote. However, the commission does not believe that we have a complete explanation of this issue. So I'd like each of the parties to respond to the following two issues. First, does the ADC have the authority to grant KAA the ability to file this petition and permanently place the land IAL designation on state lands? And I'd like you specifically to address how the land in the subject petition is held by the ADC and whether or not the manner in which the lands are held are sufficient to grant ADC the ability to authorize the petition, or whether or not additional authorization from the Board of Land and Natural Resources is necessary. And the second question for the parties is whether or not under 205-44.5 Hawaii revised statutes, state lands may be subject to IAL designation by individual lessees, or whether state lands must be designated in a comprehensive manner. If we'll do them in order. So I'll ask you first, each of the parties to address the issue of authority. And then if we resolve the issue of authority, ask for your position on 205-44.5. I'm going to allow the commissioners to ask questions of each of the parties during the course of the discussion. Petitioner. Commissioner Giovanni, excuse me.
Yeah, just a clarification. So if we get past both of those questions and the conclusion is that we could proceed, we'll take up the question of deferral or not at that time?
This is actually the substance. Well, thank you for that question, Commissioner. Either of these two matters would potentially lead to deferral. If we conclude after hearing from the parties that we believe that assent from the Board of Land and Natural Resources is required, or perhaps assent was not fully or properly given from ADC to KAA, that would lead to a deferral of the petition until we were assured that those matters were received. In addition, if we decided that we believed our interpretation of the statute, or an interpretation of the statute that comprehensive designation of state lands is required, rather than lessee by lessee, that would also lead to deferral. What your question leads me to understand is that there's an additional third sort of reason for deferral, which is the request from KIUC and DHHL.
Correct.
I think we would then take those up subsequently, should we get through the first two.
Thank you for that clarification. That's exactly what my question was.
Okay, thank you, Commissioner Giovanni. Any other questions for how we're proceeding? If not, Mr. Kodaga.
Thank you, Chair. Yes, with regard to the first question concerning ADC's authority to authorize the KAA to file the petition, we believe based on the record as presented before the commission, the answer is yes, ADC does have that authority. This is something that was reviewed and discussed at some length with ADC over a fairly extended time period. And we believe that that conclusion is supported by, as again, by the record as presented before the commission currently, which specifically includes a staff proposal from ADC staff to the ADC Board of Directors. The record also includes minutes, and that staff proposal was concerned a recommendation by staff to authorize the KAA to go ahead and file the petition to designate the KEKAHA ag lands as important agricultural lands. That staff report was acted on by the ADC board. We have copies of minutes that are verified that have been submitted by the agency directly to incorporate them into the record, submission by the agency, meaning ADC, which indicate that ADC did approve KAA to proceed with the petition for IL designation. So based on that record and based on analysis of the applicable statutory provisions, we believe that it is ADC was correct, and it is, the record does support a determination by this commission that ADC made the right decision in that regard. I should note as well that in anticipation of the discussion of this issue or issues similar to this, we did ask as a courtesy that Mr. James Nakatani as Executive Director of ADC and Ms. Myra Kaichi as Senior Executive Assistant of ADC would be available to answer questions. I have been unable to confirm or verify that they have been admitted this morning as audience members, but that was the intention. If they have been admitted as audience members, then the commission would have the opportunity, I believe, to elevate them to be panelists to address these questions directly. And I would suggest that may be something the commission wishes to do based on the specific articulation of the question that, Chair, that you just presented, given that it's very focused. Our intention was to make them available only sort of on an as-needed basis, but based on this first question that you have presented, it seems that it might be advisable for them to potentially provide additional clarification, again, if they are available.
Thank you, Mr. Kodaga. Ms. Kaichi is actually logged in twice. So that could be her and Mr. Nakatani separately. I don't know. So they are in the audience. At least Ms. Kaichi is in the audience. And I'm more than happy to admit them if the commissioners have a question for them. Mr. Okuda.
Thank you very much, Mr. Chair. First, let me make some additional disclosures. A number of years ago, I served on a board somewhat informally. Well, I guess we were actually formal participants. It was the board called of the Nisei Veterans Legacy Foundation. Mr. Nakatani was part of that organization, but I don't believe in the last 4 years I have communicated with him or been in any board meetings with him. So I'd like to make that disclosure. And during the course of my practice of law, I have dealt with Ms. Kaichi. So I'd like to make those disclosures before I ask Mr. Kodaga a number of questions.
Okay, thank you for those disclosures. Any objection to Mr. Okuda's continued participation, Mr. Kodaga?
No objection.
Ms. Barzilai?
No objection, Chair.
Ms. Kato?
No objection.
Thank you. Please proceed, Commissioner Okuda.
Okay, thank you. Council, if I can just go through just a couple of statutes so that we can place the issue of authority and then maybe look at whether or not there's adequate evidence of authorization here to proceed with this petition. The first part, and I want to just see if you disagree with this, is that HRS section 171-3 parent small a provides that, and I quote, the department, meaning the Department of Land and Natural Resources, shall manage, administer, and exercise control over public lands. Do you agree that that's what the law says?
Yes.
Okay, and if we look at HRS section 171-2, which is captioned definition of public lands, that statute starts out by stating, quote, public lands, close quote, means all lands or interests therein in the state class as government or crown lands previous to August 15, 1895, or acquired or reserved by the government upon or subsequent to that date by purchase, exchange, escheat, or the exercise of the right of eminent domain, or in any other matter, and then there's a semicolon. Do you agree that's a fair statement of the law?
Of course, yes.
Okay, but that section 171-2 also has a list of exceptions to that rule. And under subparagraph 11, one of the exceptions to that rule states that lands that are set aside by the governor to the Agribusiness Development Corporation, lands leased to the Agribusiness Development Corporation by any department or agency of the state, or lands to which the Agribusiness Development Corporation is in its corporate capacity holds title. So that's an exception to the definition of public lands that's set forth in HRS section 171-2. Do you agree with that?
Yes, that's correct. I believe that's subsection 11. And yes. Mhm.
Yes, okay, okay. And so let me ask you this, okay? So if the agricultural, the Agribusiness Development Corporation holds title to this land, or how would you describe the Agribusiness Development Corporation's interest in this land?
That's an excellent question, and it can be a source of some confusion. I appreciate the opportunity to clarify, and also would possibly again defer to Ms. Kaichi of ADC. But that said, our understanding based on the relevant documents which are in the record, the key phrase would be control and manage, I believe, in Executive Order 4007. So I believe, again, subject to check and confirmation by ADC directly, that it would probably not be correct to characterize ADC's interest as a fee interest, necessarily pursuant to the executive order, but rather ADC has the control and management. I believe the ownership, if you will, resides with state of Hawaii.
Okay.
If there's no objections from any of the parties or the commissioners, I'll admit Ms. Kaichi. Seeing none. Ms. Kaichi, would you raise your hand? Because there's two of you signed in. Using the raise your hand function. There we go.
Mr. Chair, may I proceed, or would you
Please
like me
proceed.
to wait?
Please
Oh,
proceed.
thank you very much. Oh, okay, and so now I have a question regarding a document which was received by the Land Use Commission, and it's file stamped December 17, 2021 at 9:38 a.m. And it's on the Agribusiness Development Corporation, or that's the top line. It says minutes of the Board of Director meeting for January 31, 2018. And if we look at that document, and if we can go to page, one moment, please. Page 6, okay, first paragraph. It says, and it's a sentence that comes from the bottom of page 5. Let me read the sentence that starts on the bottom of page 5. The recommendation that the board authorize the KAA to pursue a declaratory order to designate a portion. No, I'm sorry, that's the wrong section. I'm sorry. Wait one moment, please. I'm sorry, I had it right here. Mr. Chair, I'm really sorry.
Okay,
May you defer my question just for a second so that I
Sure.
don't waste everyone's time, if we can come back to me a bit later.
okay. We're also approaching 50 minutes. Does any commissioner have a quick question they want to pose to Mr. Kotiga at this time? Seeing none. Commissioner Chang. You're muted.
Good morning, Mr. Kotiga. I just have a question regarding it's section 15-15-121. Well, let me ask you, under what administrative rule is KAA filing this petition?
The criteria, let me see here. I'm thinking the most efficient way to answer that would be the rules that were cited in the petition. And if this is too broad, we can narrow it down. But we're subsections of chapter 15-15, subsections 98, 99, 120, and 121.
Okay.
And 120, of course, is the 8 criteria for the identification of IL lands.
So I guess my question, are you filing it as a farmer or as a landowner?
That's an excellent question. And we have concluded and positioned this as a petition primarily by a farmer.
Okay.
We acknowledge that the term landowner and farmer may be subject to interpretation by this commission. And so we would certainly, if the commission chose to exercise discretion in a manner that concluded that under these particular circumstances, it was appropriate to interpret the term landowner to encompass the KAA, that's something that the commission, we would not object to the commission exercising its discretion in that manner. However, we submit that our intention, and we think the clearer interpretation, is that this is a farmer application or petition. So under 205-45, we're submitting this petition with the KA as a farmer. That's the approach, if that answers your question.
Okay, and that does, because I did have, when looking at the definition of landowner, it does require a party with a fee simple interest. So it wasn't very clear in my mind whether it was a farmer or landowner. So, okay, so it is as a farmer that KAA is submitting this petition. All right, that clarifies for me at least the administrative rule that you're applying. At this time, I don't have any other further question, Mr. Chair. Thank you.
Commissioner Giovanni?
Yeah, following up on Commissioner Chang's inquiry, Mr. Kotiga, could you further explain my reading of your petition and the background for it? KAA is responsible for the management of the infrastructure and in fact is not necessarily a farmer. Could you clarify why that? I'm confused.
Okay, no. So the co-op is an independent legal entity. It's a cooperative formed under Chapter 421, as we discussed a little bit earlier. The co-op itself is comprised of farmers and nothing but farmers. There are 5 members that are engaged in farming activities under Chapter 421, Section 9B1. The co-op is expressly authorized to speak and act on behalf of its members, as you would expect. So although the co-op has a separate legal identity, it is essentially the farmers. And so it was decided that that was the appropriate entity to go ahead and file the petition as the farmer, because of there's really no there's a legal distinction between the entity and the members, but for all practical purposes, it's the farmer for purposes of this IL petition.
So do these same farmers have agreements with ADC?
Yes.
So why isn't it ADC that represents the farmers more directly as opposed to the infrastructure entity?
Right. So this is something that was also reviewed in preparation for submitting the petition, and it was concluded that the co-op is a better fit, or perhaps falls more clearly under the definition and the statutory context of 205 and the IL statutory provisions as a farmer relative to ADC. So it was decided that really, if you look at who are the farmers, you're looking at the members of the co-op. They are farmers. This is a different, perhaps a slightly different proposition when we're looking at ADC doing that. And again, I would invite, if it's appropriate for the commission, to invite Ms. Kaichi to provide any further clarification as may be appropriate. But that's the basic answer.
Are there any farmers on the specific lands that are not members of KEKAHA?
That's partly a legal question and partly a factual question, in which I would actually wish to, with the chair's permission, to confirm with my client representative in terms of providing an accurate description. But for purposes of this petition, it requires a farmer. We believe the petition identifies a farmer, and therefore it provides us a sound basis for the commission to proceed in approving the petition, because you have a farmer and you have a petition. But to answer your question more directly, I believe there are other agricultural farmers, if you will, or agriculturalists who are doing agricultural activities on lands that are not licensed to the 5 members. But I would again appreciate the opportunity to have my client confirm the correct characterization of that, if and when that becomes appropriate.
Thank you. Chair, I'd like that clarified by Ms. Kaichi at some point. I don't know if now's the time.
Now's actually the time for a break. So I'm also going to acknowledge that there is, in the waiting room, there's somebody calling in by phone from a 586 number. Ms. Kaichi, is there any chance that's Mr. Nakatani? You would have to unmute to respond. Mr. Uehara?
I was just going to clarify, that is Ms. Kaichi, actually. So I think she's
number.
having trouble with her audio on the...
Gotcha. Okay. Okay, so it's 9:54. We're going to take a 10-minute break. We're going to reconvene at 10:04. At 10:04, Mr. Kodaga, with the assistance of Ms. Kaichi, you can respond to the questions from Commissioner Giovanni. When it's time, we'll come back to the questioning from Commissioner Okuda when he's prepared. Recess until 10:04. Okay. Myra, can you mute yourself until?
All right. Yeah, make it large. Yeah.
Okay, so 1, 2.
So you gotta do the X out, bottom X on the right.
Okay, we're picking your audio, Riley, guys.
By the speaker, there you go. No, bottom part. Yeah.
I did.
Riley.
Yes, sir.
We're hearing you guys.
Sorry.
We can hear you now.
Okay. Recording is on, Chair. When you're ready.
Okay. But we're picking up your audio if you want to mute. Okay, it's 10:04. We're back on the record. We're continuing with questions for Mr. Kodaga and Ms. Kaichi from Commissioner Giovanni. So Ms. Kaichi, if you want to unmute. And I'm going to swear you in. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay. Would you state your name and position for the record and then respond to the question raised from Commissioner Giovanni?
Good morning, Commissioners. Myra Kaichi, I'm the Senior Executive Assistant with Agribusiness Development Corporation First, I'd like to apologize for all the technical difficulties. Jimmy Nakatani, Mr. Nakatani was actually present the whole time, but I think we had difficulty registering, and so he wasn't showing up. I was on video, but I have no actual camera or microphone, so I was actually on the phone. I was the 586 number.
Okay.
Anyway, so here we are. I'm actually sitting at Jimmy's desk. We decided this was easier, and he and I, if necessary, will play tag team from this camera. So the question, we've grappled with the question of whether ADC is the proper party to give approval for any matters, not just IAL designation, but any matters affecting lands that are set aside to ADC from the governor. And as Commissioner Okuda had pointed out, when our position is when lands are set aside to the ADC under Chapter 171, they're not public lands, as that term is used in Chapter 171, and that management and control is transferred. If you look at the language that Commissioner Okuda pointed out in 171-3, all of those matters are actually given to ADC or to any other recipient of a set aside. Therefore, we believe we do have that authority to allow a tenant to make this kind of designation when it is, or bring this petition for a designation when it is in the best interest of the state. We almost always, though, defer to the Department of Land and Natural Resources as the keeper of the inventory of all lands. They are tasked with knowing everything that is happening with every square foot of state lands. And I appreciate today, the discussions today, making the distinction between state lands and public lands under Chapter 171. DLNR, in our opinion, is responsible for taking care, or at least knowing, everything that's going on with all state lands. But when they give away the management and control and the authority to make decisions over state lands under 171, public lands under 171, that the receiving agency can do that. ADC happens to still keep the DLNR informed of everything that we're doing, particularly when it's something that's perpetual, and that should be included in the inventory information of state lands.
I'm going to pause right now and ask Commissioner Giovanni to clarify if his question's been answered, and if not, to restate his question.
I think she was responding to Commissioner Okuda, and she did not respond to my question whatsoever. My question, Ms. Kaiichi, was one of clarifying the respective relationship in terms of farmers between ADC and KAA. It was clarified by Mr. Kodaga. There are 5 members of KDA, which are also farmers. And my question was, could you please characterize the farmers in ADC and licenses to farmers? There's 12,000 acres there. Do these 5 farmers represent 100% of the land? Or are there other farmers involved?
Thank you. Okay, I did not answer that question. You're correct. The members of the KAA are the bigger tenants. They, of all the leased lands, licensed lands, they represent the larger share, but they don't represent 100% of all lands in KEKAHA that ADC licenses or leases out to its tenants, to farmers. The KAA is comprised, though, of these large members who also provide services, provide the infrastructure improvements, maintenance, repairs for all farmers, big or small. And the question, I think, for a landowner like ADC is whether this is in the best interest of the lands of our tenants. At least in my mind, there is no question about whether this is of how this could not be in their best interest, that if they do, these smaller farmers who struggle with sufficient capital to do undertake.
Ms. Koichi, I'd like you to narrowly address the commissioner's questions, as well as the question I presented to council, which is about authority. So it's interesting to know whether or not you think this is in the interest of the small farmers, but that's not actually directly relevant to the question in front of us.
How many small farmers are there that are not, have licenses to this parcel or portions of this parcel?
I think about 6, maybe 7. Anyway, less than a dozen. And the acreage that they comprise and the farm gate that they produce is minimal compared to the big tenants.
So what you're saying is the 5 members of KAA, which are the large farmers, members, or have larger licenses, they have the overwhelming majority, more than 90% of the land is under their control as farmers. Is that what you're saying?
Probably. I don't know if it's 90%, but it is substantial.
I'm going to leave it there. I was just looking for some clarification on who's who here. Thanks, Chair.
Thank you. Commissioner Ohigashi. And I'm going to assume that questions are directed to Mr. Kodaga unless they're otherwise specifically addressed to Ms. Koichi.
Well, I was going to follow up on some questions that, or some statements that Ms. Koichi made. The question that I have for, if you know whether, or maybe Mr. Kodaga can answer this, if you know whether all of the IAL designated areas are within those 5 or 6 farmers, 5 farmers that are in control of the KEKAHA Agricultural Association.
Doug, I guess that is actually more you.
Oh, sure. Okay. So just to take it from the top, the petition seeks to designate portions of a TMK, and this gets a little bit into the substance, Chair, but I assume it's responsive and appropriate. And the tax map key is approximately 12,762 acres. The petition seeks to designate about 95% of that as IAL, and that's about 12,123 acres that is sought to be designated as IAL. The members, the 5 members of the co-op do not license all 12,123 acres, if that answers your question.
I'm not sure. What I'm trying to get at is, from the testimony of Ms. Koichi, she's indicated that there are other farmers that comprise a small portion of the lessees on that property. So my question is are these IAL, is any of the IAL designated areas affecting these small farmers that are 5, 6 to a dozen, as stated by Ms. Koichi?
Yes, I believe that's correct, subject to check by my client representative, which is Mr. Joshua Uehara. And yes, the intention was to designate all 12,123 acres because it would be of benefit to any other farmers that happen to currently or in the future license the lands. This is a tremendous alignment.
Oh, okay, let's just focus on the question.
And the other part of the question is what notice was given to these small farmers for your application?
Notice, Chair, if I may, this is a question I would ask for the opportunity to have my client representative speak to more directly with regard to any communications that I may not be aware of. There was no, I'm not aware of any.
No, my question is really simple, is that part of the petition process that we've been told upon in other IL designation is to notify people who may be affected, have an interest in the property. It would seem that these lessees or these tenant farmers that are covered under here have an interest in the property. And therefore, as a matter of due process, I'm just wondering what formal notices were given in filing this petition, please.
Thank you, Commissioner. I'm not aware of formal notices being provided. However, I would like for the opportunity to have my client representative, which is in more direct communication with the various farming interests on West Kauai. If they would have an opportunity to clarify that, that would be appreciated.
Did you, I have another follow-up then. Did you, Mr. Cordero, file any document or any letter or any correspondence or anything within the record of this case so far that shows any type of notification of these tenant farmers?
No.
Okay. I don't have any questions.
And I'll just sort of notify your witness. And you've been in front of the LUC before. Right now, like I will call on commissioners for questions. If you have something you want your counsel to know, you can communicate with your counsel that he can say, or your counsel can specifically ask. And if I acknowledge, I'll call on you to respond to the question. But Mr. Ohigashi, Commissioner Ohigashi's questions have been answered to his satisfaction so far. Commissioner Chang.
Thank you, Mr. Chair. I'm not too sure if this is for Ms. Kaichi or Mr. Kodaga, but this is a follow-up to Ms. Kaichi. You had indicated that ADC has management control, that through the executive order, they have management control of these lands. Is that correct? Is that what you said? Is that what you said?
Yes, that's correct.
Okay. Do they, and in that executive order, is there a reverter clause that says if the land is no longer used for the purpose of the executive order, that it would revert back to the land board?
Yes, it does.
Okay. All right. So then now my question is, I guess, to this, this is probably to Mr. Kodaga, it's a legal question. Landowner is defined as a fee simple, having a fee simple interest. In my view, that is separate and a part of a 171-2 public lands. It is a question of who is the landowner, which is, again, separate from whether these are public lands. So, so my question to you is, would you agree with that, that the definition of a landowner under this 15-15 I think it's, I guess it's 3, the definition of landowner, it says having a fee simple interest. So given the reverted clause and given that ADC only has management authority, and again, none of this is dealing with the substance of your petition. It's more procedurally so, okay, so, and I know you said you are filing this petition as a farmer, but I look at 15-15-121B1, authorization from the applicable landowner. So notwithstanding that you are filing this as farmers, it still has a requirement of the authorization of the landowner. And the landowner is defined as a fee simple interest. So what is your opinion as to whether that requires the Board of Land and Natural Resources to provide authorization, or is it just ADC through their board action?
Yeah, thank you, Commissioner. I understand the point that you're raising, and the petition as drafted proceeds on the assumption that the appropriate authorization would come from ADC, and that's based on the basically Executive Order 4007. which gives them control and management. So we felt that that was the appropriate legal analysis, was for them to be considered having the ability to authorize the KA to file a petition. That's how we have proceeded. Your point concerning the definition is well taken, but our interpretation of the rules is that it would be appropriate for ADC to provide that authorization, again, based on the overall context, in particular, the language of 4007. Ultimately, this is a determination to be made, obviously, by the commission, but that's our position.
But you would agree that with the reverter clause, that the land board still is still the fee simple owner.
Again, this is getting into an area where we would, to a certain extent, feel that it's appropriate to defer to ADC on how it characterizes its land interest, because it has a land interest that we don't. We were not given the land. My client was not given.
Briefly, Mr. Kodaga, you won't answer that question, but you're suggesting ADC can.
Yeah.
Yes.
Okay. All right, thank you. So Ms. Kaichi, do you have a fee simple interest in the land? Does ADC have a fee simple interest in the land?
That's such an interesting question, and I think you have raised the crux of the issue. Anytime the issue of the fee simple ownership of state lands arises, and in my former life as a Deputy Attorney General, every time we encountered this, it depended. The answer depended on the situation, and I can appreciate your likening the reverter interest of DLNR to the fee simple interest, like a or even like a lease, where at the end of the lease, the fee, the possession and all entitlements thereto reverts back to the fee owner. I appreciate that. I never actually got a consistent position from DLNR. At that time, I dealt mostly with the land division attorneys. It seemed to vary. I don't know that in this particular situation, the land board would take that position, that the reverter is tantamount or indicates that the DLNR holds a fee. I do remember that there were times when DLNR would take the position that it's the state of Hawaii, it's the nebulous state of Hawaii. Land division, or DLNR, is just the keeper of it. They're responsible for it. But the lands are not, fee is not held by the Department of Land and Natural Resources. It's the state of Hawaii. So and that may be true. If you look at the Bureau of Conveyances and the land court, sometimes the owner is recorded as the state of Hawaii. Sometimes it's recorded as state of Hawaii DLNR. When we hold the fee, it's sometimes referred to as state of Hawaii. We ADC, sometimes it's state of Hawaii, comma ADC. It seems to vary. I don't know that we have I can provide an accurate opinion right now on really the status of the fee simple ownership, and in whom that fee would lie when it comes to state lands.
Okay, well, I appreciate the explanation. I was a former Deputy Attorney General to advising DLNR, and I think we consistently took a position, fee simple, especially if there's a reverter clause, is with the Board of Land and Natural Resources. Management authority may be with the agency that's been EO'd, and I don't think the board oversees the management. But if there's any potential interest that may affect the fee simple, especially in the interest with respect to the reverter, I think it has, at least it's been my experience, that the practice has been to go back to the land board to get their approval. But that may be another, but I think that is an unresolved legal question. I think in an abundance of caution, you probably want to get some kind of a clarification on that. But I see that this is the landowner, the authorization. I also appreciated Mr. Ohigashi's comment about notice of, where these small farmers, notwithstanding that their interest is small, they still nonetheless have an interest in the property. So I think that there are some issues that seem to be unresolved. I don't have any further questions, Mr. Chair. Thank you.
Thank you, Commissioner Chang. Commissioners Cabral and Ohigashi, with your permission, I have one narrow question that just relates directly to this issue that I'd like to insert here before we move on to yours. If that's okay. Okay. And I'm going to address this to Mr. Kodaga, but if you want to defer to Ms. Kaichi. You are reliant in part, I believe, on the testimony provided, Mr. Kodaga, from ADC indicating their approval of this.
That's correct.
And in the minutes from the ADC meeting of January, I believe it's 31st, 2018, which were included and are part of the record in this matter. On page 5, the minutes state, and I quote, "Therefore, simultaneous with this request, the ADC has requested that the land board also approve KAA's proposed action." So my question is, was that actually done? My questions are, was that actually done? Is there evidence in the record to indicate that BLNR has been requested? And is there any evidence that they have assented?
Thank you, Chair. I would need to defer that response to Ms. Kaichi in terms of the actual facts, what actually happened. But so let me go ahead and do that and have her respond initially.
Ms. Kaichi, was it actually done? Is there evidence in the record that it was done? And is there evidence of BLNR ever doing what was represented at the time was going to occur?
Thank you, Chair. I don't have the minutes in front of me, but
it's part of your testimony.
Of my testimony?
It is part of ADC's testimony. Submitted were minutes from the Agribusiness Development Corporation approved February 28th from the January 31st meeting.
Yeah, thank you. My recollection of that is that ADC was not taking on the responsibility of securing the approval of the DLNR or the DLNR chair or the land board for this action. We were suggesting that they also secure the land board approval of this matter. ADC, though, did, in an attempt to move this along, communicate via letter. We sent a letter to Chair Case, and I don't believe that was ever responded to. But we had never intended to actually go to the land board on behalf of the KAA to secure land board approval.
So, but there's nothing in the minutes that sort of indicates this. The minutes simply say, simultaneously request, the ADC has requested that the land board also approve the KAA's proposed action.
It was just a letter. It was just a letter to Chair Case.
Requesting that you approve KAA's proposed action?
I believe, yes, requesting consideration.
Is that in the record? Is that letter to Chair Case in the record?
I don't believe we submitted it.
Okay, thank you. I'll go back to Commissioner Cabral.
Thank you. This question was brought up by my fellow Commissioner Huigashi, and I did not really understand or feel like I got a clear answer. The other tenants are farmers that are in the same general area that are included in, I think this is for Mrs. Myra Kawachi. So I think my concern is the farmers who have been the smaller ones that are on land that is part of the designated area for IAL. Have they all been notified, officially notified, that the land that they're farming, that they're paying some type of lease rent on, has been swept up into this IAL petition?
Commissioner, who is your question for?
I think I don't know, but I would assume from this, where they've been sent, it would be for Ms. Kauchi, but I don't know in their structure who would have notified those parties.
Okay. I'm going to let Mr. Kodaga as the applicant referee.
Okay.
Are you answering this or Ms. Koichi?
Oh, sure. I will be happy to respond and clarify that, as consistent with my prior comments to Commissioner Ohigashi, that our office did not send any kind of formal notice to the other farmers. However, the KAA, as my understanding, is in routine and frequent contact with them. And therefore, Chair, with your permission, and not to complicate things or further delay this, but we do have the president of the KAA Board of Directors, who I believe could shed light on this if you're willing to have him address this.
To whom are you referring?
Josh, Mr. Uehara.
Okay. I will.
Mr. Uehara, do you
Yeah,
know? if those-
I will swear him in first.
Sorry.
You swear or affirm the testimony you're about to give is the truth.
Yes.
Okay, Ms. Cabral, Commissioner Cabral, please direct your question to Mr. Uehara.
Yeah, the question, I'd like to think is simple. Are the other farmers that lease land, so that I'm assuming there's some kind of contract, on a written contract, written agreement, and that money changes hands to have use of that land, have they been notified in an official manner that the land that they're leasing is part of being swept up in this petition to be IAL land?
I know we've had a discussion with them. We put together basically a short info document on the benefits of IAL, and particularly the tax credit incentive, and had the discussions with the other tenants. I don't know what would qualify as a formal. I don't think we sent like a certified letter or anything like that, but I do know we've had those discussions with the tenants, and this is over a process that we've been pursuing over a number of years. So.
Are you able to document that they've all been party to that, or all seen the video, or all been part of that conversation or a meeting or something?
I'd have to go back and try to find that if we can. I'm not sure at this point.
Okay. Thank you very much.
Thank you, Commissioner Cabral. I'm going to call on Commissioner Ohigashi, and then I'm going to assess the status of our proceedings. Commissioner Ohigashi.
I think that you asked sort of my question, but I am going to, if we go forward, I'm going to alert Ms. Kaiichi that on the substance, I'm going to ask this question. So if we go forward on this matter in the future, I'm hoping that you guys will be prepared to answer it. And I'm not sure if you're going, I don't think you'll do it today, but the question is really about your letter that you provided on December 6, 2021. And on the second page from Mr. Nakatani, it says that, essentially says that with the added advantages that the IAL incentives will afford, ADC anticipates an increase of revenues, increased and sustainable yields from the KEKAHA lands, which will contribute to the agricultural revenues and provide for agricultural labor. So your statement there, I'd like you to be prepared if we go forward to back that up with what evidence was used to base that on. So that's what I thought I'd use this opportunity right now to tell you. Thank you.
Commissioner Ohigashi, I said I was going to assess the status of the proceedings, but I forgot I was going to go back to Commissioner Okuda. I'll do Okuda and then assess.
Okay, thank you, Mr. Chair, and I apologize for everyone not being prepared. I should have been prepared with this question. Let me ask this, and I'm not sure whoever is the appropriate person. I'm referencing the document which was filed on December 17, 2021 with the Land Use Commission at 9:38 a.m. That's the Agribusiness Development Corporation minutes of the Board of Director meeting for January 31, 2018. And if either Mr. Kotaga or Ms. Kaiichi can look at page 5 of that document, on the bottom paragraph, kind of in the middle of the bottom paragraph, it says here, and I quote, "The petition will only seek IAL designation. There will be no request to reclassify any ADC lands. Although the ADC manages these lands, the fee simple interest in and to the lands remain with the state of Hawaii through its Board of Land and Natural Resources. Therefore, simultaneous with this request, the ADC has requested that the Land Board also approve the KAA'(S) proposed action." And I end my quotation there. My first question is, did I accurately read that section from page 5 of the document? And then my second question would be, if I accurately read that part of the document, is there any evidence in the record that the Land Board has also approved the KAA's proposed action?
Commissioner, I can respond that obviously the first part of your first question, yes, I believe you've accurately stated that language. With regard to the second question, we, on behalf of the KAA, we have not, to my knowledge, obtained that kind of formal approval. We would defer to ADC, consistent with Ms. Kaiichi's earlier remarks about the efforts that were made, apparently, to obtain that. And Ms. Kaiichi may wish to further clarify.
May I ask then that if Ms. Kaiichi has any additional items to add to that?
Thank you. As Mr. Kodaga is correct, ADC did not secure any approval from the DLNR. And Commissioner, I believe this is just a different approach to the very same conversation or discussion that we had with Commissioner Chang a moment ago. This is really the same issue in my mind.
Okay, and if I can ask one question, and Mr. Chair, if I'm out of order at this point, you can tell me, but what prejudice would the KAA or anyone else have if this matter was deferred so that some of these issues can be clarified or be made more certain? Can anyone point to any specific prejudice that would occur by a deferral at this time?
Commissioner, on behalf of the KAA, I believe that there would be concerns. I'm not certain that I would characterize them as being prejudicial in the sense of a procedural matter. I would request, again, Chair, if I may ask Mr. Uehara, who has been focused on the practical benefits to the co-op members and to all of the other users of the KEKAHA ag lands, perhaps he could say just a little bit more about the nature of the intended benefits, and those which could give rise to certain concerns in terms of the timing. But I want to stress that may or may not be necessarily be prejudicial to be directly responsive to the question. I believe Mr. Uehara could shed a little bit more light on that.
I'll allow a brief answer, Mr. Uehara.
All right. Thank you, Chair, Commissioners. I'm not sure if this answers the very specific question. There would be a benefit to the farmers on the property and to the KAA if the petition is granted at this date, but it's not something that I would say. If I can certainly understand, given the discussions, if there is a need to defer to clarify some of the issues before we're able to proceed.
Thank you very much, Mr. Chair. I have no further questions. I do apologize for not being prepared. Thank you.
Not a problem. Commissioner Cabral?
Thank you. I think this would go back to Josh Uehara, and thank you for your input. I'm fixated on the other leases as well as even your members. Were these leases, the other leases on the land, and are your members notified of the hearing today that was taking place?
Certainly our members were, given the direct involvement with the KAA. We didn't specifically reach out to notify the other tenants on the property. And just to clarify an earlier question, so the members of the KA comprise about 94% of the land under license with ADC. So those members were notified as part of their involvement with the KA, the others were not.
Okay, well, thank you for your clarity there. I will say that if this meeting is deferred and we have another hearing, I sure like it to have to think that everyone's been notified of it. Okay, makes me always want to include everybody. Okay, thank you very much, though.
Thank you. Commissioners, I want to take up the issue of the status of our proceedings and the procedures I had laid out. I had laid out that I wanted to sequentially deal first with the issue of whether or not BLNR approval was required. And I'll just say at this point, I don't know that we can resolve that here today. We have contradictory statements on the record and contradictory assertions. We haven't taken up the issue of whether or not there is a broad obligation for the state to designate all IAL lands under its control at one time, or whether it can be done in a ad hoc or piecemeal fashion. We have also not addressed two other issues that have emerged today. The concerns of neighboring landowners / land users, KIUC and DHHL, and the fact that apparently some of the tenants whose lands would be included in this might not have even received notice of this meeting today. It's my assessment as the chair, it's like at this point, we could go on down the road of trying to address each of the questions that I laid out, but I believe they're all pointing towards, frankly, for the interest of the applicant, deferral is in order at this point. And I would much rather have a start of our next hearing on this matter be prepared for all the parties to actually brief these issues. Now, whether there needs to be a briefing on the issues of KIUC and DHHL, I don't know. All they said was, hey, we just heard about it, so we want to study it. Maybe they will have issues that need to be resolved. Maybe they'll be fine with things. We don't know what the small tenants might be thinking because apparently they weren't ever told. We do know that the questions about BLNR's issues, ability to approve or requirement to approve on this or not, as well as the issue of comprehensive thing can be briefed on. So my inclination is to not go through what I think would be a more unproductive morning, but instead move towards deferment with our next step being briefing at least on those two threshold issues of BLNR's requirement for approval and whether or not the comprehensiveness. Now, I will say this is actually entirely possible between this hearing and the next hearing for ADC to follow up on its letter to Suzanne Case and say, hey, can we get this on the board agenda? And that would actually dispose of the question of whether or not BLNR needs approval if approval is obtained. And then we would just be left with the one issue. That's where I'm at right now in the interest of all the parties' time and really in the interest of what the applicant is trying to achieve. I'll recognize the commissioners. Commissioner Chang.
Thank you. I appreciate the chair's inclination. I would like to hear from OP, from both the Office of Planning as well as the County of Kauai with respect to this very limited question of authorization before we take action on the deferral.
Commissioner Giovanni.
Yes, thanks, Chair. I just wanted to put something in context for everyone's benefit. We talk about the small landowners not being members of KAA, representing only 6% of the land. That's 720 acres. That's non-trivial to me. Also, in the commentary by KIUC, they mentioned that the West Kauai Energy Project would just take a small portion, the word, quote, small portion. I live in the area on Kauai that's neighboring that. I follow these projects pretty closely in their development. They're also looking at several hundred acres of this parcel. That's not so small in my view. So I just wanted to put in the context for all the commissioners, what's small to some people is not small to others. Thank you.
Sorry, Commissioner Giovanni, does that speak to the question of whether we move immediately to deferral or whether we continue on with our proceedings?
I support your inclination. I would also support Commissioner Chang's comment to hear briefly from OP and the county on this matter.
Okay. Commissioners, anything further? Again, I'm trying to run these proceedings in an efficient manner that's of use to all the parties. Okay, seeing none, I'm going to say then, if there's no further questions for the petitioner at this time, I'd like to hear very briefly from the county and OPSD if they desire on the issue of BLNR jurisdiction. And then we'll move to deliberation over whether or not to defer or to continue on with the other issues. Ms. Barzilai.
Thank you, Chair. At this time, I am in support of the chair's preference to brief these issues and move forward at a deferred time with a more formal understanding of authority. However, my comment on what we've been discussing this morning is as follows. At the outset, I am in approval and the county is in support of the OPSD comments on the matter of public lands that were filed on December 17, which discuss HRS 1712 and exclude ADC lands from the interpretation of public lands. This is simply on the matter of public lands. With regard to the appropriateness of petition by farmer or landowner, I do support that under 1515-121, farmer may bring this petition. However, Commissioner Chang's discussion is highly persuasive on the fact that authorization must come from the applicable landowner. Based on this morning's discussion, it appears that this may only be shown by conveyance documents as to who is the actual applicable landowner in this matter. As a separate matter, we have the concerns of Commissioners Ohigashi and Cabral regarding notice to the individual farmers. I believe that this is separate and apart from BLNR authority and should also be addressed. Finally, as stated in the petition, it is ADC that directly leases to these farmers and not KAA, and this raises another fact. With the complication of the ADC minutes, which indicate that land board approval was suggested and not received, and the exhibit cited by Commissioner Okuda, I do believe that a deferral would be appropriate today. Thank you, Chair.
Thank you, Ms. Barzilai. Commissioners, are there questions for Kauai County? It's a rare honor, Ms. Barzilai, to not have questions from the commissioners. We're clear.
Thank you very much, Chair, and thank you, Commissioners.
Ms. Kato.
On the issue of deferral, OPSD agrees that the matter should be deferred so that the various issues raised today can be properly addressed. On the issue of authorization, I know that there are differing views, as Myra and Commissioner Chang were discussing earlier, but my understanding is that the state of Hawaii is the fee simple owner and that it's under the control and management of ADC for the state of Hawaii, as opposed to BLNR, based on the set aside that's in the Executive Order 4007. So in other words, that BLNR does not control or manage this land on behalf of the state of Hawaii, ADC does. Under HRS 171-3, BLNR has management and control over public lands generally. As Myra pointed out, a set aside to the ADC accepts it from public lands under HRS 171-2. So I believe that that takes it out of BLNR's control under HRS 171-3. To OPSD's knowledge, ADC deals with the KEKAHA ag lands without the need for approval by BLNR on any matters such as leasing out the lands. So OPSD does feel that that ADC does have the authority to bring this IL petition or to approve KAA to bring the IL petition. But again, if this matter is deferred, then we would have additional time to further research the matter.
Sorry, I
that's all
didn't mean to interrupt you. I didn't mean to interrupt you, Ms. Kato.
Oh, no, that's okay. I think that's all the comments that I have.
Okay. Questions for OPSD? Commissioner Chang. I saw the eyebrows move before the hand went up.
Couldn't get my hand up fast enough. Thank you, Chair. Ms. Kato, and I am going to give you an opportunity to more thoroughly brief this issue, but do you view management the same as fee simple?
No, I think that the state of Hawaii is the fee simple owner. As opposed to necessarily, BLNR.
Okay.
And I think that for the purposes of the state of Hawaii, the control and management of the lands are on behalf of the state of Hawaii, the fee simple owner.
Then let me ask you this question. Who approved the executive order? Who granted that? Because that would have been the fee simple owner. So who did that?
I mean, sorry, I am not super familiar with the executive orders, but
Why
I
don't you
thought
put
that
her
was,
out of her misery, Commissioner Chang, because I think you know the answer.
is it
I
BLNR?
know. Yeah, so I know, be careful, Ms. I know, being a former deputy AG. So again, I am going to, I think what my concerns and issues are. I would ask that you more thoroughly brief that, as well as Ms. Kaichi. I think there is a distinction between management. For example, if ADC decided they're going to sell this land as a manager, I think the land board would want to have some input into that. So again, no need to answer that question, but I think you know the position, and I would appreciate having a more thorough briefing from OP on that, because clearly this is not going to be the last time this issue comes up, especially with ADC. What is the distinction between management of the land versus fee simple owner, especially with the reverted clause. So you may also want to look at that executive order too. So I have no further questions, Mr. Chair.
Anything else, commissioners, for Ms. Kato? Commissioner Okuda.
Thank you, Mr. Chair. Following up on Commissioner Chang's questions, Ms. Kato, if when you do the additional briefing, you look at that executive order, which was signed by James Iona at that time, acting as acting governor. And what it does say in the sentence, it delegates to the Agribusiness Development Corporation, and I quote, the control and management, close quote. So if you can consider that in whatever subsequent briefing you do. Thank you very much, Mr. Chair. No further questions.
Thank you. Commissioners, anything further? Commissioner Ohigashi.
More of a comment. I think that if they receive Board of Land and Natural Resources approval, this renders this whole issue moot. So I foresee an opportunity from Ms. Kaichi's department to pursue what they had written down in their minutes and decided to pursue.
Thank you, Commissioner Ohigashi. Anything further for Ms. Kato? I'd be interested in hearing from Ms. Kato, even though it's not, you didn't write ADC's minutes. They clearly seem to indicate they thought they needed approval at one point. Otherwise, they wouldn't have written the letter asking for approval.
That may have been just a question. That's speculation on my part. I don't know what happened at their meeting or how that was decided.
But I read the statement correctly, right? I didn't read the minutes incorrectly.
I recall seeing that, but I couldn't say. Sorry.
Anything further from Ms. Kato? So commissioners, I don't want to, well, let's see, procedurally. I'm moving towards a request to deferral or a move to defer with a clear sort of minimal requests and then sort of additional suggestions. And I will offer the applicant the opportunity to respond. I want either a sort of additional briefing on the specific issue of whether or not BLNR authorization is required, responding to the points raised today during discussion, or verification that BLNR has approved it before it comes before us. I'd like a briefing on the issue of whether or not this can be done in a piecemeal fashion, or whether or not there's an obligation to look at the important agricultural lines of the state, at least regionally, if not by island, as I stated earlier. And then moving on to more of a suggestion, having done this job for a number of years, when you have notable agencies and neighbors showing up at a hearing saying, hey, we never heard about this, it really makes everybody's job a heck of a lot easier with a little more outreach before bringing something forward. It would behoove the applicant to do outreach to any and all affected parties, including their own tenants, so that there's not questions about this. I want to make a little space. I don't want to give extensive instructions, but a little space to ask the commissioners if there's any additional things they would hope would be addressed the next time we gather on this petition if we move to defer. Commissioner Chang.
Thank you, Mr. Chair. In addition to the questions that you've noted, one would be, who's the appropriate applicant? Is it ADC or is it KAA? As it is clear that KAA does not represent, or they, that there are other lessees to ADC that are not here. So that would be, to me, another question. And following up with Commissioner Giovanni, explanation that these are not small. 700 acres, that's a substantial amount. So that would be an additional question, Mr. Chair.
Thank you. Anything further, commissioners? Commissioner Giovanni?
Yeah, I don't have a good understanding or feel for the issues that were generally raised by Mr. Isla, how long it might take them, what would be appropriate for them to amount of time that they would feel comfortable coming back before this commission with the matter resolved to their satisfaction. In other words, I'd hate to defer this to too short a period and not give them enough time to work out whatever those differences are. So was it worth any time today to get a better feel for what those issues might be and how much time might be necessary to resolve them?
Mr. Oradenker.
Mr. Chair, we could not get this matter back on the hearing schedule until April. So I would assume
that would assume that's adequate time to brief on these issues as well as to do any sort of coordination required.
Correct.
Anything further, commissioners? If not, I want to hear from Mr. Kodiga.
Oh, thank you, Chair and Commissioners. Chair, the specific question before my client would be whether our position on the deferral, just to be for clarity.
That's correct.
Okay, yeah, we have no objection. We understand the concerns that have been raised, and we appreciate everybody's time and efforts, especially this very busy time of year. and we will absolutely do our best to work collaboratively with all parties and stakeholders to address the questions to the satisfaction of the commission.
Excellent. Commissioner Okuda?
Thank you very much, Mr. Chair. And sorry for not chiming in a little bit earlier. Specifically, I would ask the parties to comment or discuss, or if it's not applicable at present, to explain why not the statement that was in the minutes that I had read. And that specific statement is, and I quote, "Although the ADC manages these lands, the fee simple interest in and to the lands remain with the state of Hawaii through its Board of Land and Natural Resources. Therefore, simultaneous with this request, the ADC has requested that the Land Board also approve the KAA's proposed action." Close quote. If that statement is no longer operative, I ask, and people don't have to follow my request, but I ask that an explanation be given why that statement is no longer applicable for us to go forward. Thank you very much.
So here's what I'm thinking we might do, and I'm going to look to Mr. Ordenker for his sort of reactions. I would entertain a motion to defer with a request that the parties brief on a specific set of issues that have been raised today, and that the Land Use Commission staff summarize these issues in a letter prepared for my signature to the parties. And that the next hearing on this matter would be taken up with a discussion of these matters so that we can then move forward to the case in chief. Is that, Dan, something doable? You're nodding your head, but your head in my screen is like 3 pixels tall. So if you could orally.
Yes, Mr. Chair, that is acceptable.
Okay, Commissioner Ohigashi.
I'm wondering if we'll need also, just to protect in the future, a request to the AG for comment on the issue of intervention in this matter, as the published, or as the opinion that we released with regard to the Honolulu IAL lands indicated, is that there is levels of due process that may be appropriate in a particular matter. And therefore, as it applies to this IAL petition and the already released opinion, how does that affect intervention rights of Department of Housing?
If I may, I think we could address that in an executive session agendized for the next meeting on this matter.
That's fine with me.
Okay. Thank you, Commissioner.
I thought we made it public this time.
Yeah. But if we're going beyond that, I don't want to go through that whole loop again of asking for opinion and making additional information public. Commissioners, does somebody want to make a motion to the effect that I've discussed, requesting that we defer matters on this, we ask for briefing on the issues that we've raised, and that a letter summarizing those issues will be sent to the parties prepared by the staff and signed by the chair. Commissioner Giovanni.
I so move, Mr. Chair, that we defer this matter and ask our LUC staff to prepare a letter to the parties that summarizes the issues to be briefed before this commission, as you've described.
And then I see hands from both Commissioner Ohigashi and Cabral. I'm not sure. Commissioner Cabral.
Thank you. I want to second that so that we can all move on. Thank you.
Okay. Commissioners, we have a motion before us. Is there any discussion? Commissioner Chang.
Yes, I'm inclined to support the motion. In addition, I do want the parties to take some initiative. While the letter may indicate the issues to be addressed, they may not be exhaustive. So I think the parties have heard what the commission's concerns are, and I would hope that they would exercise their own initiative. If there are issues beyond what's been listed, you will address those as well. Thank you.
Thank you, Commissioner Chang. Commissioner Giovanni?
Yeah, a number of the issues that have come up are legal issues, and I'm not going to speak to that. I will defer to my commissioners that are better versed in that area. But my interest is, and I hope the parties take this seriously, is anyone who has a interest in this land, 12,000 acres, whether it be the small leasee, whether it be the large leasee, or whether it be the other entities, the neighbors, DHHL and KIUC, who's looking to be involved, that their interest be taken seriously in this period where so you can come back before this commission in unison and say, we've worked it out. That would be wonderful. So I just encourage all the parties to put some diligence and some time together to resolve the issues before they come back before this commission. Thank you.
Thank you, Commissioner Giovanni. Is there further deliberation on the motion before us? Going once, going twice. Seeing none, Mr. Ardenker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to defer this matter and have the parties brief the specific issues raised in this hearing as set forth in a letter to be prepared by staff for the chair's signature. Commissioner Giovanni.
Aye.
Commissioner Cabral.
Aye.
Commissioner Chang.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Wakuda.
Aye.
Chair Schroeder.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 6 affirmative votes.
Okay. Thank you, commissioners. Thanks to all of the parties for making some progress on the somewhat complex matters that are before us today. I believe that we have no further business. Am I correct, Mr. Ardenker?
That is correct, Mr. Chair.
Okay, Commissioner Cabral?
Yes, this is undoubtedly completely out of order. But do we have the ability to go back to the legislature and tell them that they need to clarify, clean up, or uncomplicate this IAL matter? It seems like
As of the third Wednesday in January, yes.
okay. Thank you. But no, I mean, seriously, they've passed on great, beautiful concept, but it really has just been met with just complicated problems.
Quote a famous commissioner, lipstick on a pig.
Yes, thank you. Thank you. Thank you.
Okay, so commissioners, parties, we have no further business. And noting that, I wish you all happy holidays and declare this meeting adjourned.
Merry Christmas.
Kaliki Maka, everyone. Aloha.
Aloha, mahalo nui to everyone.